Hi, everyone. Thank you all for being here today. My name is Matt Kugazaki. I am the Pro Bono Director here at Inland County's Legal Services. Very excited for you to join today's webinar. The title is Small Business and Nonprofit Essentials, Privacy Law Fundamentals. And we are very excited for this webinar specifically because we've heard from a lot of our small business owners the importance of privacy law. There are a lot of questions on people's minds about how it may impact their small business and their nonprofit. As a reminder to everyone, Inland County's Legal Services is a 501c3 nonprofit organization, and that we are started here to over 60 years ago to serve San Bernardino and Riverside counties. Kayla Henderson, who's also at this meeting, and I run our small business legal program, and we have created a program that helps serve small business owners by providing free legal services to those who are eligible. We've advised business owners in the areas of entity formation, contract law, trademark, IP, a whole bunch of areas. And this is our first program on privacy law. So we're very excited to be here. I will, in a few moments, introduce Iryna Barash, who is our speaker today. She's a privacy law expert who's going to talk about a few things. Oh, thank you, Iryna. These are pictures of all of us here. Again, I'm Matt Kugazaki, the Pro Bono Director. Kayla Henderson on the far left, she's an attorney from our organization as well. Many of you may have met her. And then Iryna Barash is our featured speaker today. And I'll let her talk a little bit more if she wants to, but she is a privacy law expert that her job is to advise on privacy law issues impacting businesses. So we are really, really excited to have her to deliver this information. I know I do not have a lot of privacy law experience, and as many of you know, we rely on the generosity of time from our volunteers, and Iryna is one of those people, so we're very, very excited to have her here. If you go to the next slide, Iryna, I will give first a legal disclaimer. First, as this is a webinar, this is meant to provide information only. It may help you assist you in spotting legal issues that are relevant to your small business in the state of California. But as we all know, with every legal issue, there are many, many, many factors that are considered specific to your business about whether a certain law may apply. But even if it doesn't apply, whether you may still want to have best practices in the area of privacy or any other area. This is a long way of saying that if we are not providing legal guidance today, no one from ICLS, and neither is Iryna, who will be speaking, and we're not entering into an attorney-client relationship with any attendee. All that said, we are hopeful that this information is helpful, and as many of you know, Inland County's Legal Services does offer a small business clinic, and we will share those application forms to you in the chat a little bit later. But if you are interested in learning more about our services and applying individualized virtual services, we are happy to review those applications. And if you are eligible and have more questions about privacy law and any other areas of law, please let us know, and we will see if we can provide further assistance. I think with all that intro, I am going to, one other thing, Iryna is going to be speaking for over the next 45 minutes or so. I'm sure many of you will have questions. If you have questions, please feel free to hold them till the end. We're going to have a Q&A session at the end. If you all put them into the chat, I'm going to facilitate the Q&A. Like if you have a question and something comes up, please put it in the chat, and then we'll make sure to ask Iryna that question at the end. If anyone has any other questions after this session, I will email all the attendees so you have a way to easily contact me. In the meantime, please feel free to email me or put any information in the chat. With that, I'd like to introduce our featured speaker today, Iryna Barash. It is so great to have you here. We thank you very much. This is a question that's, privacy law has been on our minds as an organization, how we can better help small businesses understand what to do in the realm of privacy, especially in this heightened climate where we all know if we are looking at the TikTok hearings that are going on about their privacy related concerns, but also hearing about data breaches at companies. We know this is a big topic, especially for our small business owners that are collecting customer data have websites that are collecting cookies and other data. So we are very, 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 very excited to have you here. And I'll hand it off to you right now.
Thank you, Matt and Kayla. Hello, everyone. My name is Iryna Barash, and I'm a privacy counsel at Autodesk. Please note, as Matt mentioned, that any of my statements during this presentation are not to be construed as legal advice or opinions of Autodesk company. With that said, let's get started. So in the next hour, we will be talking about privacy fundamentals. Specifically, we are going to talk about privacy basics, including some important terminology, discuss applicability of certain privacy laws to small businesses. We will discuss some strategies for compliance with those laws. And at the end, I'll share some resources that may be useful, helpful for your compliance effort. Now let's discuss some terminology we should know to navigate more complicated privacy topics. Terminology and definitions in California, US federal and global privacy laws are varied and disparate. So for the purposes of this presentation, for the sake of simplicity, we will use the definition of personal information, that personal information is any information that relates to or describes an identifiable individual. Please keep in mind that some data elements taken alone may not identify an individual. For example, a zip code. But if combined with other data elements, they will in turn identify an individual. So we treat that as personal information. Whether personal information is protected by a particular privacy law depends on the law's definition, which may refer to personal information, personal data, personally identifiable information, or protected health information, and so on. But please keep in mind that some personal information is considered sensitive personal information. For example, social security number, ethnic origin, and the definition of it differs per jurisdiction. So depending on the data protection law that applies to your business and its definition of sensitive data, you should determine whether your business processes sensitive personal information as well as personal data or personal information, and ensure compliance for such processing, because processing of sensitive personal information may trigger certain legal requirements. For example, under the CCPA, California consumers now have the opt-out right concerning the use of their sensitive personal information. So businesses should examine their use of personal information as well as sensitive personal information and comply with applicable laws requirements. Now let's discuss who the key parties of the personal data processing are. Those are controllers or business under the CCPA, which are companies that collect and process information for its own purposes. For example, a retailer with respect to clients' data, they basically decide on the purposes and means of the processing. In other words, on why and how the personal information is processed. The next is the processor or service provider under the CCPA, which is a company that processes data on behalf of a controller. Processors should generally process data for limited purposes defined by the controller and follow controller's instructions. For example, here, the payroll service provider that assists an employer would be a processor. And finally, data subject. means a person whose personal data is processed. Some statutes may protect more limited groups, for example, children, and so on. What's important here, companies have to clearly position themselves as, and their business partners as the controllers or data processors to ensure that they can identify and meet their respective obligations. Also important to know that small businesses may not face all of the compliance burdens of a large business under, for example, the CCPA, but the new California privacy law changes the landscape for businesses, including small businesses that fall below the threshold of the law's requirements. From working as a service provider to companies that must comply with the CCPA, to dealing with consumers that will expect more now from businesses on privacy, regardless of their size. And finally, the concept of processing. Processing essentially means any handling of personal information. So basically, whatever you do with personal information manually or using automated means, including accessing, storing, etc., is processing. So the key concepts we have just discussed are relevant and applicable for compliance efforts with the vast majority of the US and global data protection laws that we will discuss in more detail a bit later. The next slide illustrates the privacy regulation activity around the globe. As you can see, the privacy is heavily regulated in Europe, US, Canada, China, and Australia. It's also a general trend that the regulatory landscape for privacy is rapidly changing and becoming more complex. So why do you need to be aware of this? Because failure to comply with global privacy laws may negatively affect your business and result in significant fines. Now let's discuss which US and global laws may or may not apply to your business. In the US, there are 5 states where the privacy laws are enacted. Those are California, Virginia, Colorado, Connecticut, and Utah. And several more are pending. And we will see the detailed chart demonstrating the US privacy regulation activity in a minute. I should also know that historically, the US has the sectoral model of data protection, as opposed to European comprehensive model. And this sectoral framework protects personal information by enacting laws that address a particular industry sector, for example, to protect medical records or to protect consumer financial transactions. So companies should comply with federal and state laws with respect to specific industries as well. In regard to online data collection, there are also specific laws regulating online privacy, such as, for example, Children's Online Privacy Protection Act, which is also known as COPPA, that was enacted to protect children and place parents in control over what information is collected from their young children under the age 13. Also, we have California Online Privacy Protection Act, which is also known as CALOPA, that requires operators of commercial websites that collect personally identifiable information from California residents to comply with the privacy notice requirement. I would pause here for a moment and stress that this law, CALOPA, is applicable to businesses of all sizes that collect personal information from California residents online. We will take a closer look at CALOPA's requirements in a minute. There are also other privacy laws that regulate online privacy. And now let's take a look at European data protection laws. European data protection laws usually have extraterritorial scope. For example, the GDPR applies if your business is established in the European Union or is offering goods or services in the European Union or collect data of individuals in the European Union. So you should not assume that if you're the US business or small business, global privacy laws do not apply to your business. Also, depending on your business's data processing practices, other global laws may apply to your company. Please note that some of them, like for example, Chinese personal information protection law, also have extraterritorial scope, meaning that they may apply to companies outside of those countries. Now let's take a look at the US privacy regulation. Unlike many European, Latin American, and Asian countries, neither the US nor California has enacted one comprehensive data privacy statute. Currently, federal privacy bill, American Data Privacy Protection Act, also known as ADDPA, is under review. So you should be aware of multiple statutes that regulate data privacy and consider applicability to your business. In terms of enforcement, California Attorney General will continue to enforce the CCPA and other California privacy laws, and the newly created agency, it was created by the newly enacted CPRA, which is called California Privacy Protection Agency, is only tasked with enforcing the CCPA. At the federal level, the FTC has protected consumer quite effectively based on its powers to enforce general unfair competition laws and some specific privacy laws, including COPPA. The current focus of the regulators is on the children privacy notices and opt-out requirements. So you should consider implementation of the opt-out mechanism where applicable. For example, if your business is using targeting advertising. Now let's take a look at the specific US privacy laws. I've decided to start with California Online Privacy Protection Act, as it applies to any operator of online services within or outside California. So the companies should comply with CALOPA if they collect personally identifiable information of California residents online, which means it may apply to your online services. The CALOPA protects consumers residing in California with respect to personally identifiable information that companies collect online about them. And in this context, consumer means any individual who seeks or acquires by purchase or lease any goods or services. Please note that operators of business-to-business websites are not primary target of CALOPA. And the next question is, what needs to be done to comply with CALOPA? The key requirement here is to post a privacy policy on your website or online services and follow the policy. What this policy should include? First, data categories. notify users about the information you collect. If and to the extent consumers actively provide the information, for example, during a registration process, a short summary list of data categories should suffice, as the consumer will know what data the company collects because the consumer actively enters it. But more details might be needed with respect to passively transmitted data, such as whether an application automatically transmits location information. So businesses should strive to provide particularly detailed descriptions where the company collects data without active participation of or perception of the data subject. For example, via internet cookies, online tracking, and so on. Next, third-party sharing. Usually, personally identifiable information may be shared with providers, hosting service providers, in process of merger or acquisition. And therefore, practically all companies have to make certain basic disclosures regarding their sharing with third parties. Further, if the operator maintains a process for affected individuals to access and update the information, the policy should describe that process. Next, changes. The company should describe in its privacy policy the process by which it provides notice of material changes to its privacy policy. Also, companies should identify the privacy policy's effective date. And last but not least, do not track signals. In 2010, the US Federal Trade Commission issued a privacy report challenging internet browsers to provide do not track feature, also called DNT. This feature allows consumers to avoid having their online actions monitored. A DNT clause is where you let your users know whether or not you respond to their DNT request. You are not required to respond to requests under CALOPA, but you are required to disclose whether you do or not. So the key requirement here is disclosure. I should also mention here that according to the CCPA, however, businesses are required to treat automatic signals as opt-out requests with respect to personal information sharing, but it's if CCPA is applicable to your business. Speaking of privacy policy generally, what is that and why we need it? So privacy policy is a comprehensive description of the business's online and offline information, personal information processing practices. It is usually issued by the business or data controller. Why it's important? These days, almost all entities on the internet need to have a privacy policy. Of course, you may be able to avoid it if you keep no data and sell no data, but even private bloggers have to consider why a privacy policy may be essential for them. Also, consumer privacy laws are quickly growing in number and strength. Both consumers and business partners now expect you to tell them how you use and guard their personal information. So the first reason to post privacy policy, it's required by law. Second, it helps to avoid hefty fines for non-compliance. And last but not least, it promotes transparency, which in turn helps to build trust with your consumers, with your customers. How often should you review your privacy policy? general recommendation here is to review it at least once a year. But it's not recommended to wait if the changes, if the change is required to comply with the new law, or if there are any major changes in your processing activities. So if you wait too long to update your privacy policy with the new regulation, you are defeating the purpose of the policy to notify users. And translation. Is it required to translate your privacy policy? Generally, under the CCPA, businesses should make privacy notices available in the languages in which the business in its ordinary course of business provides contracts, disclaimers, sale announcements, and so on. So there is no requirement under CALOPA, but under the CCPA, the Attorney General expects you to translate into the languages you have your legal documents. So what your privacy policy should include? This slide shows some basic suggestions, but please note that you should ensure that privacy policy includes all the requirements under privacy law that applies to your business. At minimum, your privacy policy should include your legal business name, categories of information collected, how you collect this information, why you collect this information, whether or not you sell or share the information to a third party, and how they will use that information. Also, how a user can opt in or opt out if this requirement is applicable, and how users can contact you for other information related to data processing. Also, your privacy policy should include effective date, description of any changes made since the effective date, and be clear and easy to understand. Next, let's take a brief look at other state privacy laws. Let's start with the California Consumer Privacy Act, or CCPA. I'm not going to spend much time discussing it in detail because it's a huge topic and a complex law. So what we are going to focus on is just criteria of its applicability to the businesses. And if you determine that it might apply to your business, you should take further steps towards compliance. So the California Consumer Privacy Act is the most comprehensive consumer privacy law in the United States that applies to certain businesses that process personal information of California residents. We will discuss the criteria in a moment. And this law became effective on January 1st of 2020. The CCPA has been amended by California Privacy Rights Act, or CPRA. The CPRA introduces new obligations such as data minimization, storage limitation, and required risk assessment. It also grants consumers certain new rights and creates an enforcement and regulatory entity, the California Privacy Protection Agency. The law became effective on January 1st of this year, and enforcement will begin on July 1st of this year. Also, I'd like you to be aware of Virginia Consumer Data Protection Act, or VCDPA, which has many similarities with the provisions of CCPA and CPRA. However, it's narrower in scope. It does not apply in the business-to-business or employment context. There is no private right of action under this law, so Attorney General can enforce it, and it became effective on January 1st of this year. Colorado also has its own similar law Colorado Privacy Act, which also has many similarities with the provisions of the CCPA and CPRA. And it comes into effect on July 1st of this year. Now let's discuss applicability of the state laws that we have just talked about. Let's start with California. Small businesses can be exempt from CCPA compliance requirements if they do not meet any of the following requirements. First, annual gross revenue of 25 million. Second, CPRA raises the threshold from 50,000 to 100,000 consumers whose personal data is sold, bought, or shared. Please note that shared is defined narrowly to require a nexus with cross-context behavioral advertising. So if your business is not selling, buying, or sharing personal information, you might not meet this criteria, this threshold. And third, a business can also become subject to CCPA if it derives more than 50% of its annual revenue from selling or sharing personal information of California residents. Same here, if your business is not selling or sharing personal information, you might not meet this requirement. But you should audit your practices to make this determination. Please also know that CCPA and CPRA apply only to for-profit entities. For small businesses that are not explicitly covered by these terms, there is still the possibility that some of the law's requirements will nevertheless apply to your organization. The primary way this will happen is if your company is considered a service provider by a larger business that is covered by the law. If your company works with the larger businesses and is considered their service provider, the larger business will need to put in place a contract to govern your relationship with the consumers and may require to implement a delete method. So the personal information you receive from a business covered by CCPA is deleted when an appropriate consumer request is submitted. You can also see the requirements for the Colorado and Virginia on this slide. Similar thresholds are set in those states. However, those laws require just processing as opposed to selling, buying, or sharing in CCPA and CPRA of personal information of 100,000 consumers annually. Are there any exemptions to compliance with, for example, the CCPA? Yes, in addition to exemptions for certain types of information and activities, CCPA exempts certain healthcare providers, credit report agencies, and other companies partially or fully from CCPA requirements. This is because other federal laws, such as HIPAA and so on, may regulate that processing. The benefit of being excluded from the law's terms is obviously that the organization does not need to increase its compliance spending in order to meet the demands of that law. It also does not, on its face, fall within the scope of the new private right of action for consumers against businesses that fail to implement reasonable procedures and practices. Now let's switch gears for a minute and take a look at our European laws, such as the GDPR and UK GDPR. There are, of course, other European regulations, but I'll focus on the most common, so you could consider whether it's applicable to you. First, GDPR, as we already discussed, applies to all companies that process data of the European users. So if you believe you may process it, you should take steps for compliance. You should be aware that unlike the US laws, GDPR requires to have a legal basis for processing, which means that companies cannot legally process any personal data without meeting at least one of the 6 conditions, which are consent, performance of contract, legal obligation, protection of vital interest, public interest, and legitimate interest. GDPR also sets up certain mandatory requirements on data transfers, processing of special categories of personal data, which is similar to sensitive data in the US. Compliance with the data subject rights and data security terms. As to the UK GDPR, after Brexit, the UK is no longer regulated domestically by the European Union's GDPR. Instead, the UK now has its own version known as the UK GDPR, which is very similar to the European Union GDPR. There are also other global laws, such as, for example, Chinese Personal Information Protection Law, which is also known as PIPL, or Brazilian LGPD, that may apply to your business if you process any personal data originating from China or Brazil. As I mentioned earlier, you should always be vigilant and not assume that if you're the US business, global privacy laws do not apply to your business. So the privacy laws are complex and include many compliance requirements depending on the privacy law that applies to your business. On top of drafting the privacy policy, which is a very basic requirement the company should follow, you may also want to consider the following steps that you may need to take towards compliance with privacy law. For example, for the CCPA compliance purposes. First, honor consumer rights. Consider establishing any mechanism needed to respond to consumer requests. Second, data governance. Audit your data collection, storage, and management processes, including what you share with third parties. It's also prudent to exercise data minimization principle, which means that your business should not collect the data it does not need to provide services. It's now applicable to both US and European requirements. Third, data security. Even though we haven't discussed data security at today's webinar, it's a very important aspect of the data protection. So you should audit your practices and mechanisms in place to prevent, detect, or correct security incident, as well as breach detection and breach response protocols. Please note that CCPA does create a private right of action arising out of data breaches. And after you determine which privacy law applies, you should also enter into appropriate data processing agreements required by applicable law. Next, opt-in, opt-out requirements. Modern privacy laws grant individuals rights to make informed decisions about the collection, use, and disclosure of the information. Businesses should know that although specific requirements can vary across regulations and engagement contexts, some processing activities, like, for example, using tracking technologies and targeting advertising, require notice and consent. Generally, consent tends to fall into two camps. opt out, for example, in the US, and opt in European Union. The main difference between opt-out versus opt-in is who makes the initial choice, the business or the individual. So if your business is involved in those activities, you should make it easy for consumers to opt out of data selling, data collection, and data sharing without explicit consent if you target the US consumers. And last but not least, do not overlook the legal requirements if you process children's data. It may require separate notice, parent consent, and other requirements. Now let's summarize all that we have discussed in this presentation. First, you should determine which laws apply to your business and stay current on the news to update this assessment as needed, and remember that global laws may apply to your business as well. Second, audit your data collection, storage, and management processes, including what you share with third parties. In other words, know your data. Third, develop and implement a data privacy policy that keeps you in compliance with any applicable laws. Fourth, establish any legally required data response workflows, for example, for data subjects, delete requests. Next, assess your marketing and web tracking activity and implement any legally required mechanism, depending on the applicable law. And assess your data security, breach detection, and breach response protocols. And I wanted to conclude with some resources that might be useful in your privacy compliance journey. The first link is to the International Association of Privacy Professionals, where you can find a lot of free and up-to-date privacy materials, news, relevant articles on privacy topics, etc. There is also a helpful web page to track US privacy legislation activity. The second link is also maybe helpful for checking on the regulation applicable to small businesses related to privacy. And of course, the link to the FTC's website if you would like to get more information on their enforcement activity.
All right. Thank you, Iryna, so much. We will move on to the question section, but I will say this is very helpful. I learned a lot. My first question, and I think it's based on something I learned here, is a lot of the businesses I think that are in attendance and some of our, a lot of the business that we serve are pretty small, and they may not be subject to these various laws. If a business, and this is something that we can help businesses determine, and we'll include the links to register for more extended services with ICLS in the chat shortly. But if a business is determined not to be subject to these various laws because they're so small, or they're not, in the practice of actually using or monetizing data, are there still benefits to having a privacy policy, both legally and just in general? If you have that would be great.
Yeah, that's a great question, because I believe I devoted 3 slides explaining why privacy policy is important and why it's important, and even that private bloggers should consider having it right now because it's beneficial from different perspectives. First, there are still laws that regulate online privacy. So if you offer something, your goods or services online, and collect any data online, you should comply with these requirements under California Online Protection Privacy Act. Also, it's beneficial for establishing good relationship with and trust with your customers and consumers. Yes, and the negative effect on the opposite side would be facing hefty fines for non-compliant if you overlooked some laws, and California and US generally have a lot of laws. A privacy notice, I would name it as a basic current requirement for the privacy compliance purposes.
Great, thank you for highlighting some of that. The next question we have is from one of the attendees, Mandy Johnson. She asked, which I think applies to a lot of our small businesses, when using platforms like Shopify, for instance, that have privacy policies, can the small business, do they rely on those larger platforms to update their policies when changes are being made? Can the small businesses who are selling products on Shopify or Amazon or elsewhere, can they benefit from those privacy policies by the larger platforms? I was just wondering if you had any thoughts about that question.
That's also a good question. And usually the controller or the business explains and discloses in its privacy policy the business's processing activities, not their partners or advertising partners. But it's also good to explain what happens next to the data. For example, that you share certain data for advertising purposes. And of course, you need to disclose in your privacy notice your business's processing activities and practices. Because as I mentioned, the data controller or the business is responsible for posting relevant and accurate privacy policy.
That makes sense. So it sounds like if you're operating on one of these larger websites or partnering with them, then you should consider having your own privacy policy that discloses what you're doing specifically with the data. And in addition, your customers or consumers may also be aware of Shopify, like a separate policy, because they're using the data, in a different way. Does that
correct?
All right. And I don't know if you know this, but the other part of the question is, where can business owners check for updates when working with Shopify and other larger companies? I don't know if you know that, and it might be specific to a site like Shopify or Amazon, and maybe that's something that we can follow up on, just separately, our organization on when Amazon, Shopify, eBay, and some of these other platforms update their privacy policies, but I'm not sure if you have any thoughts.
Yeah, the big platforms usually have their privacy policies and also the terms on which they work with smaller businesses. So you should go to those platforms, the website, and check the terms and privacy policy and specific requirements. For example, for targeting advertising or whatever the activity is, there are specific terms that the companies post and update on their website.
Okay, great. Another question that I had when going through this that I think would apply to many of our businesses have websites. And I know earlier in the presentation, you mentioned that privacy policies, and if you're obtaining consent, you want to make sure this is conspicuous, that it's very clear on a website. And are there any thoughts that you have on how to make that, just practically speaking, what does it mean to be conspicuous on a website? And then also for businesses that do not have a website, do you have any thoughts on if, they have a brick and mortar store, but they are still collecting data maybe through their customers and storing it? Do you have any thoughts on what, how they should get their privacy information and policies to their customers?
Conspicuous meaning that it's not hidden somewhere and easy for customer to navigate and to find it. There are no specific requirements that would regulate that. If you do not collect data online, then privacy policy requirement may not apply to you. You should first, as I mentioned earlier, you should determine which law you are trying to comply with, and
Great.
then check that law's requirements.
Great. And that makes sense. I mean, I think for our businesses, like what you just said, I'll highlight, if you have a privacy policy or any policy for your customers, don't hide it somewhere on the website. A lot of times people are like, we want to put the products up in center, and that makes a lot of sense. But if someone can't find, if there is an issue, you don't want an argument from the customer who has that issue saying, they had to click a few boxes to get to the policy that, is trying to help you as a small business owner. The next question I have, and I have literally no idea about this. You mentioned that privacy laws are complex. There are a lot of laws. We can tell that you mentioned several different laws that may apply. How often, and there is going to be no specific answer, but if you could give a little insight on how often do these laws get updated? And it kind of goes to the idea of, we have a privacy policy, kind of how often maybe should you, as best practice, revisit it? And how would you even know if there's a big update in the law?
Honestly, you should be subscribed to any sort of newsletter to track this activity, because currently there are 15, I believe, pending laws in US only. So 15 states, 15, yes. And also there is global activity, but it may not necessarily be applicable to your small business if you do not, for example, collect data or deal with data originating in India. So you don't need probably know that much about Indian privacy law. But in respect to the US privacy law, you should be subscribed to any sort of newsletter or visit this link that I provided that helps to track US legislation activity. How often, it's hard to say. Maybe while we are talking, there is another law. Yeah, it's really, really rapidly changing, and I don't know, once a month probably would be.
Yeah, I mean, there's a lot going on in privacy.
Yeah.
We have another question from Hassani Hawthorne, who wrote in the chat, and I'll just read it to you, Iryna. In a nutshell, if my business is based in California, which I think every business that ICLS served is based in California, but say that a customer registers information from another state, or maybe even another country. So we focus our business in our area, but then we get information from residents of other locations. Do we only need to be compliant with California laws, or is there something we may want to consider compliance with other states' laws or federal laws or other countries' laws?
For the US, I would suggest compliance with all state laws, because you never know where this data comes from. For the European, for example, data, if you do not target all those European individuals and do not try to collect their data, or do not offer your goods or services in the European Union, you may not, but you should carefully assess your activity, what you are trying and where you're trying to target your consumers, your audience. It can be that even if you do not, if, for example, if another state's resident enters the data online and he or she is able to demonstrate that you meant to advertise your services somewhere outside of California, the law of that state may be applicable. Privacy law may be applicable to your business as well.
That makes
sense. So general practice is try to comply with all the US laws and assess the applicability of other global laws as well.
That makes sense. I will also add, I think Hassani, your question brings up a good point, and Iryna's answered that if you are having customers outside of California, there is a chance that privacy laws, but not only privacy laws, other laws are going to apply. Because, you know, in the United States, oftentimes, even like a contract, if you enter into a contract with someone who lives somewhere else, there's often, and you know, it's complicated, but an analysis to determine whether or not that other state where that person lives contract law will apply. So it's, I think Iryna's question is not just limited to privacy. One thing I will mention, and if we are nearing the end of the webinar, Kayla, just a couple chats above, she did enter the links for you to apply if you are interested in learning more about our services and potentially receive additional guidance in privacy law or in other areas for your small business. Kayla put the English and Spanish applications in the chat. And I will say, kind of echoing what Iryna says, and in a lot of areas of law, it's very complex. So if we are able to provide more assistance, our organization, ICLS, will try to do that if you apply. Any other last minute questions, or it doesn't look like it. Iryna, did you have any final thoughts to give?
No, just wish you good luck in this compliance effort, and thank you for inviting and having me during this hour.
Absolutely. Thank you so much for being here, and thank you to everyone who has attended. We have recorded this webinar, and we plan to circulate the recording of the webinar either later today or tomorrow so that you can reference it. And again, please always feel free when we circulate it, either me or Kayla's email address, probably both of us. So feel free to reach out and to ask more questions. And if we can provide more services, we will work to do that. But lastly, thank you, Iryna. Thank you so much for your time, for putting together the materials and everything. I thought it was incredibly helpful for me and our business.
My pleasure.
Absolutely. All right. Well, thank you all. We will end the webinar now. And if anyone has any questions, please feel free to reach out.